Any mention?
May I please, Your Lordship, I beg to mention supplementary hearing item number 15, Lordship.
It was fixed for a specific purpose. 15. Who's right?
No, it didn't come up earlier this week when Lordships weren't here. That's why it's been fixed today again.
That is
Okay. No objection.
No objection.
What's the matter about?
about the service.
Payment of dues.
Yes.
2 weeks. Okay. The prayer.
Similar prayer for item number 16 also, Lordship.
Settlement release.
Yes.
Okay.
So I am appealing for the respondent, Lordship.
Highly obliged.
Yes, yes. That's it.
May I please, Your Lordship? Item number, my lord, 14, my lord.
14.
Yes, my lord. Yeah. My lord,
What's
kindly
14?
2 weeks, my lord, my lord. It's for hearing, my lord. Not yet treated.
What's the matter about? Why is it too long?
This is the matter about the appointment without advertisements.
For adjustment. Normal school matter, no?
My lord,
School matter.
land donation, my lord. My family has donated the land, my lord. My father expired.
But that cannot be ground. Because gift is without considerations.
Due to family
Here they said only
condition,
because
my lord.
I gifted the land, the job was given to me.
But at that time I was in class 12 and my father expired due to family, looking at the family
You have
condition.
to remove the school from your land then.
My lord. Already established, my lord. There's a gift deed, my lord.
Okay.
Yes, my lord.
Yes.
Highly obliged.
I would beg to mention item number 11. Well, this case we are trying to settle the matter outside the court, my lord.
Respect.
Yes, Lordship.
Yes, as talks of settlement are going on, this matter of 2 weeks. Yes.
Obliged.
Item 11.
Yes, Lordship.
Yes.
I beg to mention item 14 from supplementary list. My conducting counsel, senior counsel, he got some conjunctivitis, so my senior conducting counsel, he got some conjunctivitis. Eye affection.
14.
Yes, 14.
Yes.
Highly obliged.
That's it.
Your Lordship, I beg to mention item number 12.
My list is
I pray for some more time. No
no
objection.
objection. So you take turns. Where's that MS Marpana? You take turns with her. Or what arrangement you have? She comes for 1 week, you come for next week. No. Yes. 2 weeks, yes.
Thank you.
May I please, Your Lordship? I beg to mention item number 15.
The list is gone. The list is gone.
No objection. If Your Lordship would allow some time, Your Lordship, for this matter.
Here for the petitioner.
Yes, Your Lordship. No objection, Your Lordship. No objection.
2 weeks. 3 weeks to DC matter. Yes.
Much obliged.
Wait, please, Your Lordship. Your Lordship, I beg to mention item number 13, Your Lordship. Your Lordship, on the last occasion, this matter was posted for Lok Adalat, Your Lordship. But the matter could not be settled, Your Lordship, so the matter was referred back to His Honorable Court, Your Lordship. Your Lordship, I pray for 2 weeks' time, Your Lordship.
No objection, as usual. Yes. Yes.
Supplementary list, item number 1.
May I please, Lord?
What is this?
That is the appointment, approval of the appointment matter, my lord, because we have filed, but we have withdrawn, because some party we are not included in the previous writ petition, so we have withdrawn and filed fresh, my lord.
Yes, MS Kolni.
My lord, I'll take instruction. I'll take notice on behalf of respondent 1 to 4, my lord.
Number.
1 to 4 state respondents.
Mr. Sarika. Issue notice. MS Arkoni, GL, GH present. Acceptance on behalf of respondent 1 to 4. Richard next step for issue notice on the remaining respondents.
Yes.
3 days. List after 3 weeks. For instructions affidavit.
May I pray, my lord, pendency shall not be...
Pendency of the writ petition shall not stand the way of the petitioners taking passing necessary orders.
Much obliged.
Item number
in
2.
connection with prisoner services. Yes, Mr. Wajini.
Your Lordship, I am a casual worker here, working in PWD office, Central
Where's your
Division.
appointment letter?
It's at page, can you repeat? We are the regular casual worker, Your Lordship.
You're regular casual. You're already a regular casual worker.
Yes, yes.
Where's your appointment letter?
There's no appointment letter, Your Lordship.
There's no appointment letter,
Then?
Your Lordship, here. There's only.
The foundation of your course of your case will be on your claim to you're asking for what, for RCW status.
Yes, Your Lordship.
Then where's the appointment letter?
There is no appointment letter, Your Lordship, in here.
Then he's not never appointed, and how is he claiming for RCW?
Because our only case is that the rule has not been complied. They never complied.
No. Where's the appointment letter, Mr. Wajiri?
We don't have an appointment letter.
You don't have appointment letters.
We're not given the
Even
appointment.
temporary appointment letter is not there.
No, this is 59 days, if I'm not mistaken.
Where is that?
At this stage, we are not able to produce it, Your Lordship.
Yes.
We are not able to produce it out here right now.
What are you asking? Asking for regular casual worker status?
Yes, because we have been
Because you
working
said
for
you're a regular casual worker.
Yes, Your Lordship. Yes.
But you have not got a status. You want the status of regular casual
No,
worker?
we are already regular casual
Where is that
worker.
order? You didn't draft this petition. That is why whoever you would draw it, you file a complete one. We cannot go ahead. Court cannot go ahead on. There's no appointment letter. MS
No appointment.
Sure.
Yes, Lordship.
Except for this at page 21, Your Lordship, this list of RCW under executive engineers, because I'm representing.
You're representing whom?
Because I'm representing most of the RCW workers.
How can you represent all individual cause of action?
This is under the same cause of action. We want the same.
They must have a different. Where are the appointment letters then of those people?
Then we'll
At least if you want to come for relief.
Yes.
If you represent people, you have to come with something to substantiate a petition.
All right, Your Lordship, yes.
Mr. Tiki Wajiri, after hearing the subject, seeks to withdraw the application, but you've had a pressure, so advise.
Much obliged.
Matter stands close for withdrawal with liberty aspirate. You get correct facts.
Yes, Your Lordship.
Item number 3.
Much obliged.
Yes.
May I please, Your Lordship?
Yeah.
Your Lordship, the petitioner is before Your Lordship with the prayer for the benefit of disability pension or a lump sum compensation.
How much percentage of disablement?
Disability percentage was not a certain, Your Lordship, here.
Not a certain.
No.
When was he discharged from service?
He was discharged from service on certificate annexure 4.
2015.
August 30th August 2015.
And during that time to this time, what you were doing?
Your Lordship, they have filed a writ petition.
After 15.
Yes.
Then what happened?
And the respondents did not give effect to their impugned order of 25/2015, which is passed in WPC number 2010 of 2015. But thereafter, on 2016, he was discharged from service.
No, but he went on disability only. That he was. What was your ground of 15 petition?
For reinstatement in service at that time.
Where was that order?
Annexure number 1, Your Lordship. Page 26.
This 26 is.
Sorry, Your Lordship, it will be annexed common judgment on order dated 15/3/2016, page 27 to 96.
2796. No, but these are all for disabled only, no?
No, Your Lordship, only for him. Then they have given him retirement
where does it refer to him only that regarding the? You said you went 2015. Where's that order? What's his name?
His name, Arjun Singh Chip. Where is that?
Yes, Mr. Dr. Mazika.
May I submit, my lord?
Yes.
My lord, some other matter also pending, my lord, identical matters. Here what happened, my lord, in the year 2015, because of low medical category, some were suffering from obesity, my lord, some from high blood pressure. So they are compulsorily retired under that was Rule 48, my lord. So they came before this honorable court, my lord, around 80 or 85 of them. That point of time, Justice Sen passed an order dismissing all their writ petitions, my lord. Now he was one of those writ petitioners, my lord.
Who was dismissed earlier on?
My lord, the writ petitions were dismissed. This honorable court's learned single judge held that there is no place for unfit people in the armed forces, my lord. Only some of them they went on appeal, my lord, to the division bench. The division bench order, my lord, at page 159.
Just say what's the
remanded back the matter to learned single judge, my lord. Only qua the petitioners, my lord. Only qua petitioner, qua the appellants.
Yeah, okay.
Now ultimately, because there are other proceedings pending in Guwahati High Court also, ultimately the learned single judge allowed the writ petition, my lord. But only those matters which were restored back, my lord. Only those who went on final appeal. As far as he is concerned, my lord, his matter is restituted, my lord.
Is that correct?
Your Lordship, your...
is that correct? What
yes.
is you filed a petition, didn't file an appeal?
No.
Then appeal was successful?
Yes. On a bona fide belief that when the reliefs granted to others because we're dismissed together on
low medical. Similar relief, yes.
Yes. Because the other petitioners...
Page 159, the division bench direction is very clear, my lord. I read one sentence only, my lord. 159, my lord.
Yes.
But conclusion, my lord. Accordingly, and in view of the above, these appeals stand allowed to the extent indicated. The impugned orders qua the petitioners' appellants are set aside and the related writ petitions stand restored for reconsideration by the learned single judge.
Yes.
Thereafter, my lord, the learned single judge, Justice Dingdong, my lord, that is at page 168, my lord.
He allowed the repetition, my lord. Then he should be given the same benefit. You're taking substance. Because then...
file an affidavit, my lord, but because the directions by the division bench is only qua the petitioners.
That's why she's come with this fresh petition. To seek to carve out an exception. Heard MS Hitman, Contempt issue notice. Dr. N. Mozika, learned DSGI is present, with so-and-so present, except we have all the responding of the notice called for. Just after 4 weeks for affidavit.
Okay.
Item number 4.
Sometimes they have reasons, so they can't come. They have financial reasons, other reasons that they cannot come for appeal.
But difficulty, my lord, 8 years out of service, my lord, to reinstate them.
No, that'll be a different matter, but then let them try their luck.
My lord, in this matter, on the last date, on 12th September, when this matter came, my lord has directed to the respondent to file, if necessary, to file an affidavit before the next date of hearing. We just got a copy of the affidavit filed by the respondent in the morning, my lord. I'm not sure whether the affidavits are on record also or not, my lord. What I'm praying, my lord, is it's been the 56 pages affidavit. I need some time to go through, my lord. I will file it. Let this matter come up on Wednesday. I'll file it, the rejoinder, on Tuesday, my lord. We can file. And in the...
The PUPN submits that as the affidavit has been served.
Have you served today, this morning itself?
This morning itself. No? Maybe allow some time to file a rebuttal to the same. This matter on Wednesday. for further orders?
My lord, my lord.
Wednesday is?
Wednesday
20th.
would be 20th, my lord.
On 20th.
Obliged, Your Worship.
Main list item number 1.
This matters may come after weeks.
Why?
Because I have gone through and some instruction was short because they are reviewing this orders quarterly.
I don't understand. What are you saying? What they're doing?
They are reviewing the order quarterly, in which order it has been shown that he is having this excessive workload. So I need this.
Mr. Debnath, this matter appeared last on the 1st September. Now we're sitting on this 15th. It's more than 2 weeks. You have got 1 week's time to obtain instructions. 1 week extra time you've availed also. Now the only consideration that why won't he allowed to take part in tender just on the reason that he's overburdened. Yes.
So this is I think in this matters. Next review what's happened, just to have this one. It after weeks you say done by this time.
See, you see the last order dated 21st of August. You don't have a copy of the order also. You have a copy of the order?
Yes. Yes.
You give it to your colleague. Missing para 10.
So you will see in this matters. That's why I think that if the matters next subsequent review it is orders come, then this earlier order it will be null and void.
You're supposed to come with instructions, Mr.
So in this matters, this whether next review.
Asking for time is not it's not a given. That when you give an undertaking to the court that you come with instructions, your people should understand also that if instructions are to be forthcoming within 1 week, we've been very lenient because maybe in the organizational problems you might be having. But if from 1st September till now 1 week been given, when we'll ask the people to come here tomorrow or Monday or Tuesday. The court, see, the thing is that court doesn't want to adopt these measures. They don't want to ask officers to come honestly. But if the councils and their principals, whatever, who engage the council, engage this kind, do not attach any urgency to court matters, you'll be compelled. I've seen a lot of matters where instructions have just been, for instruction just goes on unending. Especially matters handled by you, sorry to say.
I don't know why.
The thing is that it's not a question you don't know why, but if this happens, we will be compelled to maybe it's like in contempt of court's order, they will be made to stand in court the whole day. What can we do?
It's true.
We're here to discharge, to administer justice as well. There's no personal, angle involved anyway. But if it's flouted like this, you stand up and ask for time and you think it's given. You don't even look at the order. You don't have the earlier orders. You expect that instruction I haven't got. You get in the morning. Instruction I haven't got. Okay, I'll go to court and ask for time. That won't happen in future. Let me tell you. And if instructions will be given, and if not given, the army officers appear. Yes. Once undertaking is given that on the first day when it was moved this matter, you sought time that the matter be at 2 p.m. to allow to obtain instructions. Correct?
Yes.
Do you recall that? Yes.
Yes. After that, they contacted
me. Then 21st again, Then on the 1st September, this is again, you sought for further 1 week's time to seek instruction.
Yes, after that, one person's came also here. After this, one person's came and
Well,
after
I do not
this.
know what 1 person or 2 persons came, that's not my concern.
Then after this, disappeared.
Disappeared?
This is the some material given. Same came and some is given, it is totally wrong. So I tell this is not the code is something else. And after this, so within 1 week, if not coming, they'll say then.
Mr. R. Devnath today, in spite of the court granting further time on the 1st of September 2023 to obtain instructions, prays that some more time be given. Yes, but I've noticed that this has become a regular habit to avoid effective adjudication of matters which seem urgent in nature by the state respondents. Stop. Next part. The note. This court takes note and takes note of this inaction on the part of the respondents. This court has taken note in this manner of seeking adjournment by the respondents. Stop. In the event that instructions are received within 1 week, necessary orders will follow.
Yes. This is what copy of the order.
Copy of the order be given Mr. R. Devnath. The orders followed to command the appearance of the concerned respondent in person before this court.
Lordship,
because interim orders come to the next day. Yes. It's enough because this happens every time. That not been your cases. Every time.
In reality, it happens to me, so that's why I am deducing also.
It happens only to you.
Only to me.
Very strange.
Item number 2.
Only to me. Even in this case, thrice I have given the instruction. No response.
Lordship.
Lordship, the writ petitioner have challenged that notification of 28 and under instruction and by virtue of this lower court's order dated 5/9, I have instructed the district council to withdraw the notification, and it has been done accordingly. And perhaps Lordship may peruse the. So nothing survives.
What's that letter 28? I've forgotten.
That's we have stated the election of the, and we have fixed a date for election of the Raj Sabha.
What about additional voters? Not to be included.
They'll, whatever they do, we will not interfere. The election committee, whatever they do, will not interfere.
Lordship, I'm not fully aware of this letter. So I'm praying for some more time. He's not here, Lordship. He's not available. He's having some personal difficulties.
Anyway, we take down the learned Mr. B.G. Ganta, learned senior counsel, on behalf of the respondents number
1, 2, and
respondents number
1, 2.
You don't have the brief with you?
I have not.
Then open it and see what the respondents is, counsel. You're supposed to assess
Steps
the
have been
court.
taken on respondent number 3.
Yes?
Steps have been taken on respondent
No,
number
no, you're supposed to assess the court.
1 and 2.
1 and 2. The Senior Counsel behalf 1 and 2 has produced a communication dated 8th September 2023 indicating that the impugned notification dated 28th August 2023 stands withdrawn. So, a copy of the same is submitted to the court and to the council that pays for the petition and stuff. Ms. Iwan Yang, correct? And perhaps praise that you're allowed to obtain instructions in the same. This is a matter on Tuesday, 19th. Why don't be scared? Why you're scared that the matter will be closed? Look at your file, Sophie.
Item number 3.
Lordship.
Don't be
Lordship, in fact, because now that we have withdrawn, now the election committee is already processing to hold the election.
Doesn't matter, don't take substance.
That we have no control, Your Lordship.
Item number 3.
Much obliged.
Please, Your Lordship, admission hearing.
Yes.
Lordship, as I had submitted at the motion stage, Your Lordship, just briefly.
Succession matter, right?
Yes. Lordship, briefly, Lordship, the petitioner in the year 2008 had applied for a succession which was granted
2008.
by 2008.
Okay.
The year 2008, he had applied for succession.
Yes.
And accordingly, the court, after following due procedure, granted the succession. It was
granted on?
Granted on 13/7.
2008 applied succession. 2008.
Yes. Sorry, 2006. 2006.
So who are you?
I am the brother of the deceased.
Brother of the deceased person. Okay.
Yes.
What was his name?
The name of the brothers, late Pravesh Chandra Duggal and Jagadish Kumari Duggal.
For both of the assets,
for
you file.
Some of them are jointly, some of them are separately. So these debts and securities are with the respondent. So on the succession certificate which was granted to me, I had forwarded the succession certificate in original to the respondent. Granted on 13/7/2006.
13/7/2006 granted.
Yes.
Okay.
So after it was granted, I had supplied the copy of the succession certificate in original to the respondent, and accordingly the respondent released those debts and securities. Later onwards, I found that
released?
This was released during that time only. It's a couple of months, but the date I don't remember. It was released. Now later I found out that there are other debts and securities which were not included. So I had filed in an extension. That too, these debts and security were also lying with the respondent, the same respondent. Now the extension was filed and accordingly it was granted following due procedure. This succession, the extension is dated, succession certificate is dated 08/07/2009.
Sorry, succession certificate?
That will be at page, yes, the extension. I'm here for the extension, Your Lordship.
Which page?
That will be at page 69. Page 69, and it goes all the way to page 78.
This is for extension?
Yes, this is for extension. See, the amount is 5 lakh, total amount is 5,95,000. So that's extension. Accordingly, the same manner which I have done earlier, I have forwarded the succession certificate to the respondent.
Yes.
However, in this extension, what had happened was that the respondent had refused to release the amount. Now, the ground that they have cited verbally, they stated that there's certain kind of an objection which was there. So I waited for their. They have not disclosed that, but they saying that it might be some nominee is there. So I have requested them to give me that, provide me that information, which they have not done.
You mean to say that in 2009 you received the extension certificate, correct?
Yes.
You gave them immediately after that.
Yes, immediately.
And then they have not given you those,
they have not.
Those other movement assets, whatever. And then he said there was an objection.
So I have given numerous correspondence, some letters and representation I have given them, but they have not replied. There were a few letters that they have given to me and informing me that this matter is with the higher authority. That is the only ground that they have given. You could see the last letter, kindly see, Lordship, the last letter was given to me. That is at page 82, Lordship. Can you see page 82? This letter, this is the last correspondence, 2020. Am I allowed to read you? But this is regarding the succession of so and so. With reference to the letter cited above, it is to intimate you that the matter has been forwarded to the higher authority seeking instruction for disposal of the case, which is still awaited. The case will be settled as per instruction of the aforesaid authority. However, considering the time period of pendency that they admit, that has been pending for a very long time, of the matter, the concerned authority has been requested to issue necessary instruction at the early date for early disposal of the matter. That is it.
What happened
after this letter? I did not get anything. I waited for almost 1 year.
Yes, then.
And having no other option, I had filed a writ before the single judge. That writ petition, the order is at page, Your Lordship, page 83. Now, this order is what had happened during the hearing of that writ petition. The court had expressed with the objection of the respondent that let me exhaust the remedy there in the concerned court who had granted the cessation certificate. So I conceded to that and I said, okay, I will do that and I will come back. So this order is just a small order, nothing on merits. So I conceded and I went to the concerned court, filed an application seeking one specific relief, that is to direct the respondent to release the amount. Now that order is at the concerned court, after giving ample opportunity to the respondent to give their reply to show cause.
Directed for release, what happened after that?
That is, the order is at page 84. Can you see that? 84. This is the order where it has 84 or 85. Sir. 85 is the.
Yes.
This order clearly mentioned that the respondent has failed to file show cause, and also directed the respondent to release.
Yes.
Now, whatever I have prayed from the court has been granted to me. So this itself shows it's a final order.
It is a final
so now
order.
this, after this order, it was fixed for report on payment. And instead of filing, releasing the amount, the respondent filed a show cause.
Okay, then.
Now, on the basis of that show cause, the learned trial court changed that order, completely modified that order, and based on the ground that they have filed a show cause, and now it's fixed for hearing. So this is a completely wrong order.
Yes, Dr. Mercy, what is this? This is a total travesty of proceedings.
But my humble submission, my lord, is not my lord. My lord, here what happened, my lord, the show cause which we filed before the learned trial court has not been annexed, my lord. There we have satisfied the learned court below. There are two requirements of encashing the fixed deposit certificates, my lord. Number one, that original FDR receipts have to be submitted to the post office, my lord, because this was the time when there was no online system. Physical certificates have been issued to them, my lord. Number one. And number two, there is a guideline, my lord, that a power of attorney holder cannot encash the fixed deposit, my lord.
He came through a power of attorney holder.
He is coming through power of attorney.
Originally.
No, because this person concerned is because of his age, and he has settled in Punjab. So he had this is registered power of attorney.
My lord, we can facilitate. He can approach any post office in Punjab also.
So if that is the case, if they want the person concerned to come, which they have not informed me, after this order which was passed,
I can have it. They have not annexed, my lord.
Show the records.
Because
that's why we asked the records last time. No?
According to my understanding, if this order is stopped, this is an order of the court. To stop an order of the court has to be an order. It was just a show cause.
My lord, there is something.
No, the thing is that, see, Mr. Marpan, the thing is that, leaving aside whatever, we have to look, what is a larger picture on technicalities. Show cause.
Well, here what happened, my lord, the son and daughter of the deceased, my lord, they have put objection. But we cannot go into that, my lord, because a competent court is issued a succession certificate in his favor, my lord.
And that 2006.
Yes, Judge.
We are only asking to bring the original certificate, and the successor who is having the succession certificate in his name, he should come, my lord.
Lordship, if that is the case that they want the person concerned, we can do that here. We can arrange that.
One second.
So was replying to me.
Why on the annexes show cause, Mr. Marpan? It's quite revealing. Paragraph 4 said domination with respect to deposit certificates have been registered in the names of Priyanka Dugal and Amit Dugal, and the nominees are alive. Is that correct? The nominees have further sent objection. That doesn't matter now. You can say because it's a lot of water under the bridge. But even then, you should annex the show cause.
Understand your lordship, but the previous order had said that they have failed.
No, you can't bank on the previous order. All you're saying is that for you to say that there's been the proceedings are totally unwarranted in the sense that once the final order is passed, the court under the review is filed, cannot recall its order on its own motion.
Yes, I'm going on that.
Yes.
Para 6 melody is the relevant para melody.
Whatever contention they have put in the show cause, but again, that has to be still under challenge.
But what I can do, my lord?
Send it back. Or you don't send it back to the Court of Additional Deputy Commissioner.
My lord, what I'm praying, my lord, we'll settle the matter in the trial court, my lord. We'll facilitate if the person approaches any post office in Punjab, my lord, and he brings the original certificate, we will facilitate that.
Is he filed at 227?
Yes. Lordship, in Punjab, again, he's just residing here. These debts and securities are lying here. These.
There is something suspicious in the entire thing.
It's an allegation. Lordship, these debt securities are lying here in Assam. Now, the concern, the main person here is respondent number 3, that is senior superintendent of post offices. So, if the requirement is that for the person concerned to come in person along with the original FDR, we can arrange that.
You want him to go to Punjab, number 3?
No, here. He can come here.
Your old man can come here.
At least for this, at least for this. Not during the proceeding of the case, then he can't come.
If we can come, there is no problem.
Because I've already spoken to the power of attorney. If there is
There's some problem with the power of attorney also. He's given 3 addresses as per the show cause.
Addresses?
Yeah, he stays
in Lavan.
But he said he's in Keating Road, the address here.
No, Keating Road has a business there, Keating Road. He has a shop there in Keating Road. So he's kept that for easy correspondence.
Okay, take that. This application of 227 has been filed assailing an order dated 27/7/2023 passed by the Court of the Additional Deputy Commissioner Judicial (Shillong) in miscellaneous application case number 60 T (2021) for extension of succession certificate dated 18/7/2009 granted in extension S/C miss case number 42/T2008 in favor of the petitioner. Next paragraph. Mr. S. Marpan Leonard, counsel petitioner, submits that the petitioner has been constrained to approach this court under Article 227 inasmuch as when the extension application was presented before the lower court, by order dated 26/4/2023, directions were issued to the respondents to release the amounts so mentioned in the succession certificate within 2 months from the date of receipt of the copy of the said order. He further submits that, however, on the filing of a show cause to the application, the Court of the Additional Deputy Commissioner itself modified the order without any application being made thereto, and directed that the matter that the securities, the debts and securities granted by extension succession miss case in succession miss case number 42/2008 should not be released pending hearing of the matter on the show cause. Next paragraph. Dr. M. Mozika, on behalf of the JSGI, on behalf of the respondent, submits that the show cause which had been filed by the respondents was on the ground that the extension certificate, the fulfillment of extension certificate was sought to be done on behalf of a power attorney holder, and further that for satisfaction of the same, it was deemed desirable that the person himself be present in person due to the absence of any other documents such as fixed deposit receipts. So, next paragraph. I have considered submissions of the legal counsel of the parties and also considered the materials on record. It appears that initially the succession certificate on application by the petitioner had been granted on, when was the first time?
That is 13/7.
Had been granted. Police among heard the counsel of the parties and considered the materials on record.
It appears that initially the succession certificate on application by the petitioner
have been granted in SC Miss Case number 40(T) of 2006 by the Court of the Additional Deputy Commissioner, and at that point of time the said amounts were duly released and withdrawn by the petitioner. As submitted on the discovery of additional dues on additional amounts which were present, the extension certificate, extension application was filed, which has become a subject matter of these proceedings. As the succession certificate had been granted as far back as 2006. 2006, correct?
2000.
There's no question of any reappraisal or re-examination or review of the same, and and the respondents are expected to act in accordance with law in any matter and ancillary to the and law in the grant of the debt securities as allowed by the court in the extension succession miscase. However, the concern and objections as raised by the Merit Senior Counsel on behalf of the respondents seems to have some substance, inasmuch as it has been admitted by the counsel of the petitioner also that the person to whom the certificate was granted is presently residing in Punjab, and which had caused him to authorize an attorney to receive the amounts. In this view, the matter, therefore, as agreed to by the parties, the instant matter shall stand remanded back to the Court of the Additional Deputy Commissioner to enable the respondents. Should we record it in the order?
Lordship, maybe dispose of with a direction that the petitioner in person shall appear before the respondent. Not remanded, but dispose it of by directing the petitioner to appear before the respondent, concerned respondent, with the original
FD certificate.
With the original FD certificate, instead of going there.
You have already FD certificate?
Yes, I've already.
Problem? It doesn't matter. No. The manner concerning the grant of the amounts as mentioned in the extension certificate shall be processed by the respondent number 3. But as soon as the petitioner appears in person along with the required fixed deposit certificates within a period of 1 month. In a period of 1 month from the date of this order. You have no need for remand.
No, but it is positive.
It's understood that the parties are to cooperate. How old is the man now from Punjab?
His age must be 70 plus. He must be nearing 80.
So that the matter be disposed of as expeditiously as possible. Yes. With the above noted directions, so the matter stands closed and disposed of. Lower court records to be returned.
Item number 4.
The lower court matter also stands closed.
Yes. In view of this order, the proceeding for lower court also stands closed.
Set aside that order also has
Yes,
to
not that it stand closed.
because it's fixed for hearing on towards the end of September.
Then you produce an order for the court.
Thank you.
Then they'll close it, okay?
Highly obliged.
Yes, Lordship. Lordship, the representation has been replied.
Where's the petitioner?
May I please the order? May I please the order, Lordship?
Yes.
Yes, Your Lordship. I don't have any instruction, Your Lordship, regarding.
She's brought instructions. You examine them.
Lordship,
Let's see.
it has been replied to the petitioner.
See that you give a copy to her also. Yes, this contempt application has been filed alleging violation of order dated
15/5/2023. 15/5/2023.
15/5/2023, whereby a representation of the petitioner was stated to have been kept pending in spite of the orders of this court. So, next paragraph. Today, MS Lalu has produced a letter dated 13 September 23, indicating that the representation has since been disposed of. So, a copy of the letter in question is submitted to the court and is taken on record. In view of this development, nothing survives consideration in the contempt application. The same is closed.
Much obliged.
Item number 5.
Your Lordship, we have received the affidavit from the respondent number 4 yesterday on
Respondent number 4 and 3.
3 and 4 and 5. Yes.
Your Lordship, respondent number 1 and 2 will be filed.
So, what do you want to do now?
So we may be allowed to file our rejoinder affidavit by next date.
Your name, sorry?
Kedakhar, Your Lordship.
MS Kedakhar submits that she is in receipt of the affidavits filed by respondent 3 and 4 and please be allowed 2 weeks time for rejoinder. Prayers are referred to 2 weeks. You won't record anything. I think last time already recorded that you won't file affidavits. Yes.
Item number 6.
May I please, Your Lordship? Your Lordship, the affidavit is ready. I'm just praying for 2 days' time, Your Lordship, to file that affidavit.
Your Lordship, we have filed the status report also, Your Lordship.
On some number 4?
Yes, sir, on the 4th.
Where's the affidavit?
Your Lordship, I'm praying for 2 days' time, Your Lordship. I'll be filing
2 days' time?
By Tuesday, Your Lordship, I'll be filing it.
It's a holiday till Tuesday only. I'm just asking why you couldn't file an affidavit?
Your Lordship,
how many times have you taken?
Not much time, Your Lordship.
Not much time? Yes, and service and after indicating service on the respondent 4 has been filed by the petitioner. As such, no other, only 4 respondents, correct?
Yes.
As such, service and all the respondents is complete. Stop. MS Eiling was the GA for the respondent 1, 2, 3, raised for and allowed for the 1 week time while affidavit. This thereafter also for affidavit for appearance of respondent before.
Obliged, Lordship. 7.
May it please your Lordship. Your Lordship, on behalf of state respondents, will be filing an affidavit in the course of the day.
In this case, your Lordship, I am appealing for the respondent number 7 and we have filed one.
You already filed. Yes?
I'll seek instruction, Your Lordship.
Your Lordship, I've supplied a copy to them already.
Yes, MSZE normally submits the affidavit on behalf of the respondent to file in the course of the day. So, yes, on behalf of 107, submit to Mr. Roy, the action has already been filed. This is matter after 2 weeks for the joinder venue.
Obliged, Your Lordship.
Item number 8.
Please, Your Lordship. Actually, I just want to raise this court. The
Lordship, I'm appearing for respondent number 1, 2, and 3, the state respondents. I pray for a week's time, my lord, to file the affidavit.
Why? Yes, Mr. Hassan.
Yes, my lord.
My lord, it's almost ready. It's just
For whom?
Force for Mr. Sheikh is appearing.
You
But
Mr. Sheikh.
No, Mr. Sheikh, but he's not well. Just he need 2 weeks.
Whatever
time.
he's supposed to file affidavit.
Yes, he need 2 weeks time, Lordship. He's not well.
Okay, further 2 weeks time granted to the respondents for their respective affidavits. Till thereafter. Yes.
Hello, Blessment.
Supplementary list item number 5.
Obliged.
Okay.
My lord, we have filed this application for an interim order, my lord. Here, what happened, my lord?
Lordship, before it starts, copy is not supplied to me. I am the party managing committee hearing. Without supplying copy, how is making submissions?
We have supplied a copy to the state, my lord. I'll serve him a copy also.
Who is paying for the state?
I am the affected party. It is me who advertised the post. Managing committee advertised the post.
Where's the state?
My lord, it's a lame duck managing committee, my lord, and on the fag end of their tenure, my lord, they are trying to fill up the post, my lord, in this school.
Nothing new in these schools here.
My lord, here, moreover, my lord, what is more startling, my lord, in the entire matter, lordship kindly turns to page.
But without.
Give him a copy at least. Give him a copy, Ram Music. In all fairness, we'll take it on Tuesday.
Tuesday will be too late, my lord.
Be too late.
My lord, what happened, my lord? The issue.
Give a copy, take after some time.
After some time, my lord.
You can take telephonic instructions.
Yes.
This is the age of technology. You don't have to go to Garo Hills. Give him a copy and tell the state to be present also. Whoever for the state is the one here.
Item number 6. Supplementary item number 6.
Where's Mr. Sai? Only for his reply, correct?
Is there, your lordship?
Yes, Lordship.
What do you have to say?
Am I audible to
Yes, yes.
Lordship, I just intend to rejoin on the points that have been raised by my learned senior during the course of the submission. As I could gather, Lordship, there were 2 points primarily on which the entire response is hinged. The first response is that the order of my lord passed on 11th August 2023 has virtually taken care of the 711 application and nothing survives to be decided. That was the first point that was urged by my learned senior before your lordship, for your lordship's kind consideration. The second and the only other point that was argued was that the petitioner has a valid cause of action, and therefore, since a valid cause of action exists, it is necessary that the election petition must go to trial, and there must be trial on the cause of action that has been agitated before my lords.
Yes.
Now, at the outset, lordship, I wish to take your lordship's, draw your lordship's attention to the provisions which I have invoked in filing this application. This application has been filed under Order 7 Rule 11, read with Section 86 of the RP Act. For a moment, Lordship will have Order 7 Rule 11 of the CPC.
Yes.
In particular, Lordship will find 11D.
Yes.
The claim shall be rejected in the following cases. A, where it does not disclose the cause of action which is being contested by the government senior. And B, B and C is not relevant. D, where the suit appears from the statement in the claim to be barred by any law.
Yes.
To be barred by any law. So the objection that I have raised in my 711 application is not 711A, but 711D, that it is barred by the provisions of the Representation of People's Act. Lordship will note that there is no opposition to this point at all, and rather a parallel submission has been made that a valid cause of action subsists in favor of the petitioner. It is my case before your Lordship that there is no valid cause of action also, but that stage has not come. Presently, we are arguing the 711 application. So, therefore, the stage of meeting the allegations by the petitioner has not yet come. And each of the allegations, I may just point out to dispel any doubts that each of the allegations is even otherwise false. And that also I have set out in my 711 application by saying that this is without prejudice in my rights to statement, it will become factual. That's number one. So 711D, barred by law is my first point, no response. Second is Lordship, Section 86.
Yes.
Section 86 says that the High Court shall dismiss an election petition which does not comply with the provisions of Section 81 or 82 or Section 117.
Yes.
In the entire course of the response of the election petitioner, there was no endeavor to show that Section 86 is not attracted or that Section 81 and 82 has not been met. These arguments were not urged at all before the Honorable Court.
Yes.
So that's the first point, that the provisions under which the challenge is made to the election petition have not at all been adverted to or addressed before my Lordship. That's point number one. Number two, your Lordship.
Yes.
Is that within the bar of law, within the contention of bar of law, I have argued that the requirements of Section 81 are not being met.
No, but out there his submissions were that whether the election petition is presented personally by election petitioner before the stamp reporter, that is a question of that has to be gone to evidence, because we'll have to, and that yes, this assuming not admitting, but then let it be fixed as a preliminary issue in the trial of main election petition itself. So that was his submission yesterday. Correct.
Straight away, to answer that question,
yes.
Straight away, para 14 of Jamaluddin's judgment.
Yes.
Para 14 of Jamaluddin's judgment, that is 2003 4 SC.
Yes.
In para 14 at page 271.
Yes. Judicial function.
After placitum A, there is no discretion.
Para 14? No.
Yes, para 14, it starts with the judicial function.
Yes.
Lordship will come over the page at 271.
Yes.
Placitum A. There is no discretion in receiving an election petition.
Okay, yes.
An election petition, when presented, has to be received. It is a simple, definite duty. Now, Lordship, this is extremely important. The date and time of presentation and the name of the person who presented, with such other particulars as may be prescribed, are to be endorsed truly and mechanically on the document presented. It is a ministerial function simpliciter. It can be safely left to be performed by one of the administrative or ministerial. Now, the most important fact is this judgment has in fact put out in very many, in clear terms, that it has to be presented in this manner, where the name of the person, the time when it is presented, and all other particulars are endorsed on that petition. The question of going to trial would arise if there was anything on the face of it which showed necessity for a trial. And Lordship will see the entirety of the petition. There is no such endorsement at all.
Or a stamp reporter.
There is, yes, no such endorsement by the stamp reporter, no such averment by the plaintiff.
Yeah.
The plaintiff doesn't say that I went at this time, I went in person, I made a deposition before this person, it was endorsed at this time. So your Lordship will find that in the entirety of the petition there is no endorsement at all as required by Jamaluddin Ahmad, which is dealing with the provisions of the Guwahati High Court rules itself.
What's office noting regarding the stamp reporting? You know, the often your stamp reporting from the it's not here. Who signed this? 1 second, sorry. I'm just looking. Strangely, there's no stamp reporting done here. Must be there. Yeah, but one thing, in the last page of the legislative petition, there's a signature by a stamp reporter.
Lordship will permit me to take
with regard to court fee, it's here. On the last page is stamp by stamp reporter, stamp sufficient as per authentication, in time, in form, court fee rupees 20, 14/6/23, stamp reporter, High Court Meghalaya. You can see it. Can you see it? Is it visible in the camera?
Lordship, I have the certified copy of the petition with me, and I make.
There's a note here in the last page. It's on a separate page behind the wakalat. Wakalat you won't have.
No, that I do not have, Your Lordship, because I had obtained the certified copy
of the petition.
In the certified copy, it is.
And even here, like, see there. (15/5) again on 11/5. All in all these in all the wakalats, the stamp reporting is done. So I don't know whether the petition is presented before the stamp reporter or only the wakalat is presented for stamp reporter. It's very strange.
Correct. And as Your Lordship just read with me, the requirement of the endorsement.
No, the requirement is that the election petitioner should present it himself as a stamp reporter. Correct.
Yes.
Yes. But the strange thing here is that
none of the person who presented. So even if I take it that Lordship, what is there before Your Lordship on
I think you have to come.
you
You'll come physically to examine the records. And let Mr. Kriyam see them.
This is precisely why, Lordship. This brings me to the point of section 81(3) in the first place.
Yes, just see. Let them have a look at this behind. Yes. I don't really like these stamp reporting. I don't know stamping on what, for what. Let him see also and apprise you. Is stamp reporting for the wakalat or stamp reporting for the petition?
Lordship, I think this is only for the wakalatnama, I think, Lordship, because the stamp is only of 15 rupees, Lordship. It's
okay. If they could give it before the presented before the the wakalat to get an election petition before the stamp reporter prevented them from, because strangely office noting filing note. I'm afraid, Mr. Sai, I just have to do a little bit of administrative background check.
Yes, sir.
Because there's what has happened is that usually on the front of every petition, this report is there. Here the report's not there. It must be somewhere in the records, maybe because there are many.
Because
because to proceed on the premise of your arguments that we don't need to fix the primary issue is absolutely essential. That is the court be satisfied on its own accord. We'll adjourn it for today because I'll just make a
there would have been a need to call for evidence when there would have been at least a prima facie demonstration.
Yes, exactly.
So evidence in my respectful submission cannot be called for at the asking of the election petitioner simply, and there is no assertion at all.
Let the court satisfy itself.
Yes, and Lordship will now, this is closely connected with section 81. It is closely connected with section 81.
The court understands the gravity of if you do not comply with the strict provision, understands the gravity. And the only thing is that if not presented in the proper form, or then yes,
then it has to be dismissed. Is my respectful submission, and also Lordship will see in 81(3) why is there a requirement that every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, and every such copy shall be attested by the petitioner under his own signature to be a true copy of the petition. Lordship will see the certified copy of the petition, the copy of the petition before Lordship. There is no such endorsement, there is no such attestation by the petitioner under his own signatures.
Whose signature is on the side?
Lordship will find at page 48 for instance.
Signature. Yes. 48. Right? Okay, yes. 48. Yes.
At the bottom, Lordship will find that there is a stamp. It says certified to be a true copy, and it is signed by Sayyid Mustada Ahmad, the advocate, the learned advocate. So this is not the requirement of section 81. And before pages 48, in the certified copy, there is no such signature, no such endorsement that these are true copies at all. The election petition itself doesn't have this endorsement. And that, your Lordship has seen as a mandatory requirement under 81(3).
I'm of course aware of that because when we used to election, we are very particular about this. Yes.
That has been already taken care of by the Lord's judgment. Because this cannot raise this at this stage.
No, fine. No, Mr. Jyotendra, only thing concerns the stamp reporter thing. We'll adjourn it for today.
Yeah, that is why that is taken care of by the judgment of the Abdul Jabbar. Because in the Abdul Jabbar case, what says is because preliminary issue has to be framed, my lord.
No. See, Mr. Josindro, if on the materials on the face of the record itself, it reveals to the court, then we don't need to go for preliminary issue also. We don't need to examine the stamp report also. If it's shown on the face of the record, it never went for stamp reporter, and we can't refute it any other way. Anyway,
because everything has been complied with, my lord, from our side, because see, from my petition, in my reply also that I have fully replied that because that has been complied with. And the stamp reporter fully complied with then only, because without complying with stamp reporter's report.
this court's adjourning, see, Mr. Josindro, this court's adjourning this matter on its own accord because there is a page that should be present in every petition, whether election petition or not, with regard to the report on stamps, and strangely is missing from the records here. So I'll just ask them to check the registry to check whether that's available or not. Then we can proceed from there. Yes, in the course of hearing, it appears that the stamp report, the concerned stamp report, which is to be affixed to the main petition, is not present. Is not available presently before the court. Stamp registry to verify and to produce the same. No, but this is verify as to the same stamp. This matter next week.
Lordship may list it after 2 weeks because other election petitions are also coming together where the same issue will be there. These are identical issues in all of these petitions where 711 has been made, and I'll point out the date to the learning court master.
Then yes, okay. Yes, and so on.
It can be tagged with and it can be taken together. All the matters are at the same stage now.
Better also.
Item 7.
Yes. Very strange.
Please, Lordship. Lordship, I pray for times to file the rejoinder affidavit.
Order. Yeah, Mr.
Mr. Ilalu.
Ilalu.
On behalf of Senior Counsel S. Chakravarti.
You're on behalf of the petitioner, on behalf of yes. Mr. Ilalu, you want for rejoinder? Pray for how much time?
3 weeks, Your Lordship.
3 weeks time to file rejoinder.
8.
Lordship, we have received the affidavit, so...
You have?
We have received the affidavit.
You already prayed last time. Who's MS Islong? She already prayed for time for the rejoinder since last month.
Since last. So we'll file it on the next...
You have not filed it?
No, Your Lordship.
Why?
As per instruction I got from the senior, so we won't file it.
You won't file the rejoinder? Yes, Mr. So submits and Rujan be filed. According, this is for hearing or we'll dispose it off now?
No, we'll hear.
What's there in the matter? With regard to that...
regard the payment of rent.
The landlord and the tenant.
So we'll hear it on the next date. I'll inform my senior.
If they have already made the payment. I don't know.
Already made the payment?
No, we haven't made the payment.
Not yet, yeah. Because I'm representing the state doesn't have anything.
No, this is a different matter. Yes. This is because non-acceptance of rent deposit.
Rent, yes.
We haven't received any payment yet.
No question of payment. It's a question. Anyway, none of you are know of the case. So, this is a matter for hearing. As the rejoinder, as the council petition, or matter for hearing. And so on. So, yes.
9.
Highly obliged.
Where's Ms. S. Salam? None appears for the respondent. Ms. N. Raji is present on behalf of the petitioner. Stop. It is noted that by order dated 24/8/2023, further 2 weeks' time is granted to the respondents for filing affidavit. But also indicates that the same has not been filed till date. So, in the interest of justice, This is matter. The respondents and it's not justice. This is a matter for 1 week. You don't appear next week. We'll close it.
Similar is connected with item number 11, Your Lordship.
Yes.
It's connected with item number 11 also.
Contempt.
Item number 11. Same matter.
Why same matter? This number in 9.
9, yes, Your Lordship.
Same on 11.
Item number 10.
May I please, Your Lordship? Your Lordship, in this matter, I humbly pray 2 weeks' time, Your Lordship, to file rejoinder affidavit.
How much time?
2 weeks' time, Your Lordship.
2 weeks time as prayer granted to petition filing to join affidavit. Yes.
12.
Lord, I pray for 2 weeks time, my Lord, to file my affidavit. My Lord.
Where's Mr. Sheikh for 4?
It's not here, my Lord.
Mr. Ensign, how much time?
2 weeks, my Lord.
Please follow out for a 2 weeks time to file affidavit. None appears house number 4. It's for 2 weeks.
All right.
13.
Lordship, we're still awaiting instructions from the government. We haven't been able to file an affidavit on that account.
None appears to have the petition. This matter of 3 weeks for affidavits by the state respondents.
1 to 5, Your Lordship. Bless you, Lordship.
Hearing. Item 9. Main list.
Also, item 9 to pass as well. I copy petitions. We take out matter first, Dr. Mozia. Where's Mr. Kurishi?
Second call. Item 5.
Call me with Mr. Kurishi. You given a copy?
Yes. Standing outside. Send to call.
Yes. What is the problem?
Well, here problem what happened, my Lord, we have challenged the constitution of the managing committee, my Lord.
In the main petition.
In the main petition, my Lord. Now, if Lordship kindly turns to page 10, my Lord.
Yes.
My Lord, this is an order by the Director of School Education, my Lord. Dated 6th February 2023. It says, my Lord, based on the inquiry report submitted by the Deputy Commissioner West Garo Tura, it is suggested that free and fair election for the school management to be conducted in accordance to the relevant rules and provisions for reconstitution of the Managing Committee of Bhadbadi Higher Secondary School, West Garo for the month for the smooth functioning of the school. Therefore, I am of the opinion that there is a strong prima facie material that the formation of the school managing committee was not held in a transparent manner with an ulterior motive to satisfy the intentions of the vested interests of certain groups of people. The District School Education Officer West Garo Tura is hereby directed to keep in abeyance of the formation of the new SMC of Bhadbadi Higher Secondary School, West Garo till further orders. Even in spite of this order, my Lord, the managing committee is continuing, my Lord. And my Lord, the tenure of the managing committee is till 31/10/23, my Lord. 31st October. Now what they have done, my Lord, they've issued an advertisement, your Lordship will see at page 11.
Yes.
But I have marked advertisement, my Lord, on the right hand corner top, my Lord.
Yes.
It says, my Lord, applicants are invited in standard form with 2 passport size photocopies of the educational certificate and valid mobile numbers are invited for the 2 assistant teachers posts, arts and science qualification so and so. According to NCTE norms, candidate must appear before interview board with original certificate. Local candidates will be given preference. Salary and age as per deficit norms. Last date of submission of application is on or before 12 September 23. The date of interview will be intimated through SMS, WhatsApp, Secretary, Bhadbadi Higher Secondary School, New Bhadbadi, West Garo.
Yes.
My Lord, our case is, my Lord, this managing committee went, firstly it is under challenge by way of writ petition, my Lord, and there is an order by the Director of Higher Education, my Lord. At this stage, my Lord, when their tenure is going to expire on 31st October, they have started the process of filling of the post, my Lord.
See, the order says keep on. Why are you doing this?
Lordship, because there is a suppression of facts. The relying heavily on the letter issued by the directors, directing the school educational officers then education of a school officer has clarified. The clarificatory letter is not here. This is the letter I just...
Let's see. You got my WhatsApp just now?
Yes, I got from the WhatsApp.
This is a marvel of technology.
Almost it.
So,
the Merging Committee is fully functional.
No, but the thing is that now you're saying that it's under challenge, correct? To avoid future now by issuing advertisements again.
Then what happened, Lordship? After the Merging Committee is fully functional, they file a writ petitions, is pending, they prayed for the stay orders, but they have never pressed for the staying the Merging Committee. It is continuing. They never prayed for the stay order, and the case was filed maybe last year or before last year. Now when the Merging Committee is fully functional, then we file a writ petition before this Honorable Court. Lordship may remember, very recently, WPC number 6265 of 2023.
What do you want there?
We wanted the interview board was to be approved. Lordship may remember. We filed a petition that we pass a resolution by the Merging Committee, the interview board to be approved by the directors.
This is absent dated when? Which paper? It's a long time to talk when.
It's a long time. The order dated passed by the Honorable Court is...
Advertisement is dated 4th September, my lord.
4th September.
I was stated in para 5, my lord.
This Honorable Court, the state respondent came with the instructions. They said, we are ready to approve the interview board. Only the problem is that the petitioner has not approached to the district school education officers, straightway approach to the directors. Then court has given a liberty, we file representations and we file all these applications before the district school education officer, and he has forwarded to the directors. This is the order.
See, Dr. Mosika, in these waters, no, very twisted and dangerous waters, these school management committees from the plains areas.
This is then after we file, then he forwarded to the director. And director said, put up for approval.
Okay, we'll do one thing to avoid any further legal. We'll stop all the recruitment and we'll hear these matters expeditiously.
Lordship, because there is no prima facie case, they have to establish the prima facie case first for getting the stay orders. And the person who filed these writ petitions have got no locus standi, they have no balance of convenience. Even if the process, the director has to examine, director has to give approval. After giving the approval, there will be a selection process. It is not necessary that even in the selection process we will get the approval to the teachers. So once the selection process has started,
what is the use of doing this kind of exercise, my lord? If they are not sure that they'll get approval from
no, we are not saying there is a lot of exercise to be done. Step by step.
My lord,
no selection process.
How is advertisement dated 4th if the order from the court is
3rd?
3rd.
My lord,
so without approval, you float the advertisement.
Approval advertisement was done.
Advertisement says 4th. When was advertisement done? Resolution of advertisement was done when?
Advertisement was done on 4th.
No, when was the resolution taken for holding the selection?
Long back it was taken. It was taken prior to that. Prior to that.
No, what I'm saying is this. Now you see meeting number 19. An SMC meeting with Bajbari High Secondary School held today, 3rd September, in so and so and so and so and this and so. The meeting discussed a lot regarding the order dated 1/9 pass and so and so. For approved interview board considered post selection to teachers for as per meeting number held on 30th June. So that means on 4th/9 you issued advertisement.
Advertisement.
After you already got the, I don't understand. This meeting is 3rd, advertisement 4th. We're not waiting for the approval of the selection committee.
Well, then the habit of taking innocuous orders, my lord.
No.
To represent.
It is the
very good. They crafted very well. So sometimes the court takes. That's why courts now are very conscious.
No, it is the
cautious, not conscious.
Ultimately, the officers' concerns are there. The field officers are there. SDSO.
What officers have done? Then other case which judgment will be passed shortly. Now, what does officers have done there? You're not party to those cases. The series of cases where inquiries that to be done, and what the inquiries revealed, it's they can make a big movie out of it.
My lord,
how they have twisted the system, Mr. Kurishi.
My lord, the tenure is till 31st October, my lord.
That is there, but the managing committee is still functional, drawing disbursing authority.
Towards the fag end of their tenure, my lord.
No, that is correct.
Everyone does that, a fag end of the tenure, finish off everything, finish off the coffers, whatever is there.
Appoint their own people.
Even on the last day also we can do it. So long I am functional.
The war.
Yes.
But my lord, on the face of the director's order, my lord, can they do so, my lord?
No, the clarification is there. No, but then the things are still under consideration.
Under consideration, Lordship. This is under consideration only before the department.
I don't have anything, but I beg to submit that let the matter come up on Monday, Your Lordship. So hearing can be done, and Your Lordship will be able to pass.
But some at least status quo should be passed.
Lordship, there is no. They are not going to.
Status quo also.
There is not going to pass any order. They are not going to give any approval. They are not going to give anything within these 2 or 3 days.
This miss case number
the heaven will not fall.
23 in W0249/2021. This SIMS application has been filed by the writ petitioner, correct?
Well,
seeking
the main case fixed on 21st.
Seeking interim orders to stay any new recruitment to the post of assistant teacher or any other post in new Bajbari High Secondary School, PHAT BRI has done in terms of assessment dated 4/9/2023. It has been the court has been apprised by the council of the parties that in connection with the same school 3 repressions are pending.
Yes.
3 repressions are pending.
One is disposed of, 2 are pending.
Assailing the
on 21st the date is
assailing the constitution of the present managing committee staff. In this view, the matter, this is Mr. application together with the main case. When is it coming up?
21st.
Which are due to come up 21st for consideration. Stuff. It is made clear the next date. Nothing will happen also.
Nothing will happen.
My lord, they do it in one day, my lord.
No, how can the director has
action
to...
should be taken in pursuance to the advertisement dated 4/9/2023. Give us some protection also.
Lordship.
Till the next date, we'll finish it on 21st.
Hearing? Main is item 9.
The consideration will be stopped by the director. Because it is
now next week,
it will still be under consideration only. The process will be continuing only.
Suppose the matter is disposed 21st and the managing committee goes, then everything goes. And if it stays, then we pass orders that yes, like
Monday is a holiday. Only
21st.
21st.
Yes.
Your Lordship, in the last occasion, the state respondent had filed affidavit bringing on record one complaint letter dated 13/06/2023. Your Lordship, this is allegation against the petitioner and we are denying it. So therefore, Your Lordship, I pray and seek the leave of this Honourable Court and Your Lordship to file a short reply. If Your Lordship permits, I will file during the course of the day.
We are going beyond the prayer of the
entire writ petition, my lord.
See, we go on to pray because we have to give a decent burial to entire case.
Because, my lord, our only intention, the contention of the state is that the reason we are justifying why the managing committee was taken over by the state government, because there was some discrepancy found. And in between, my lord, when the lordship has also observed that there are many things from the very beginning how the school has started. There were some issues that have been brought before your lordship. So all those issues are brought. So, my lord, the only issue which I am saying is that how long will a state government, the authorities also will take over the administration, because there was an interim order. We never had any objection to that. But, my lord, our only intention is, will it be proper for the petitioner to contest again for the managing committee at this point of time?
No, Millennial Justice demands that once allegation will be let him answer it by way of show cause, whatever. When we will take it, where's the affidavit?
My lord, the affidavit was filed on 31st August, my lord.
We received. If your lordship permits, I can file the reply today itself during the course of the day.
No.
My lord, in the second matter. Second matter. Yes. In the second. This is the first matter.
This is
in item number 10.
Okay. 31st, 320.
But this is a related matter, your lordship. 9 and 10.
What complaint?
My lord, a complaint was...
Ask him, Mr. Yes, what you want to file reply to this one?
To file reply. There is an allegation that we have violated the order of this court dated 31st 12 and this one, and that we have given the NOC. And then,
but that time you did, and this court took very serious note of it, and you had to ask for apology.
Yes, your lordship. That time there was a misunderstanding, your lordship. It's not at this time, your lordship. That time there was a misunderstanding.
So then you don't need to file reply. Court's aware of that. There's a misunderstanding.
But for this, your lordship, allegation, there's a grave allegation that we have manipulated an NOC and then taken up the money at all.
This is a recent development, correct, NOC?
My lord, yes, this is a development. My lord, the complaint came on 6.
Let him file, let him give satisfaction, let him file a small reply. Yes,
in fact, my lord, if I may only submit, we have also filed an FIR to this regard also.
Doesn't matter, let him file a reply. Yes, sir. The Council for Research prays him allowed to file a short reply to the after file respondent number 3. Bring on report letter date 13/6/2023. In the interest of justice, though this seems to be outside the pleadings and of the minute petition, this seems allowed. This is a matter of 2 weeks. We'll finish it off. We can't keep this pending like this.
My lord.